of Tennessee is now in session.
Good afternoon. Before Mr. Hibner calls the case, just a couple of quick words. If we should have any problems due to technology, whether it's because of the weather or whatever, we'll just take a short pause and resolve it and then proceed from that. Call the case, Mr. Hibner.
Ralph Hall et al. Versus Jimmy D. Tabb et al.
We'll hear from the appellate.
Good afternoon, Judge Swinney. May it please the court.
Good afternoon.
I'm Dale Condor from Jackson, and I'm representing Ralph and Carolyn Hall in this matter. And the Tennessee Consumer Protection Act is intended to prevent unfair and deceptive practices committed by business persons in their dealing with consumers and to establish some ethical conduct that would control business relations between the two. In this case, falls squarely within the Tennessee Consumer Protection Act. This case had its beginning when the Tabb brothers, they had a company called Tabb, and they bought some property over in Decatur County and began building a house on that property. And they eventually completed the house. And during the construction of the house, they discovered there were some problems with one of the floors, and they sent a crew out with materials they supplied to fix that floor. It was a soft spot at the back door of the house. There also, underneath the house, as it turns out, was rotted floor joists, and those were fixed by a method that's called scabbing, where they put a good piece of wood on each side of the rotted joist, and then block that up with support from underneath. Mr. and Mrs. Hall purchased this house. Ms. Hall was driving by one day and saw it, and she and her mother looked at it, and then she and her husband looked at it. They made an offer and purchased the house. As part of the purchase, the Tabb supplied a termite letter that they had gotten from Mr. Brasher, and they also signed the residential property disclosure forms indicating there were no known problems with the house. And they also signed the mildew form that indicates there's no mold or mildew in the house. The Halls discovered the problem when Ms. Hall saw a Terminex salesperson in the neighborhood and asked for a free inspection of her house. When the Terminex inspector got into the house, he found that there was termite damage, and there was this extensive damage from water and from rotting underneath the house on the floor joists. In order to repair that, the Halls got some estimates, and they ultimately hired Edward Jones Construction, and he came out to make the repairs. And the evidence in the record shows that in order to make these repairs, Mr. Jones had to take up the flooring system to replace these joists with new joists because they had rotted, and that this method of repairing it by putting this scabbing process was not the proper way to repair this. And the Halls had to move out of their house for several months while they were waiting for the repairs to be made by Mr. Jones. As a result of that, the Halls filed a lawsuit against the Tabbs and against Mr. Brasher, the termite inspector. And the Tabbs, of course, built the house, and Mr. Brasher was the termite inspector. And the theories against the Tabbs were intentional misrepresentation and violations of the Tennessee Consumer Protection Act because they intentionally, fraudulently, or knowingly misrepresented the condition of that property. Mr. Brasher, on the other hand, the lawsuit against him was limited solely to the statute that creates a cause of action where a termite inspector submits a false report or fails to inspect before he submits the report to someone. In this case, the proof showed that he had failed to inspect. He went to the wrong house. The case came on for trial before Judge McGinley down in Hardin County, or over in Decatur County, I'm sorry. And Judge McGinley concluded that the proof established there was extensive damage underneath the house, and he awarded to the Halls the cost of their repairs. And he found that the Tabbs knew about this, or based on the condition of the property and their involvement in this, that they should have known, and found that they had intentionally misrepresented the condition of the property when they indicated there were no problems with it. Judge McGinley, however, held that the Tennessee Consumer Protection Act did not apply because, in his words, he didn't see the Halls as consumers in a real estate transaction because in the record he said they weren't consuming anything, and we think that is the first error in this matter, is that the Halls were not consumers. The Tennessee Consumer Protection Act, of course, defines a consumer as a natural person who acquires by purchase any property, tangible or intangible or real. And that's exactly what Mr. and Ms. Hall did in this case. They acquired by purchase real property. And although the Judge McGinley did not make a specific finding as to the fact that the Tabbs were in fact in business and constructing these homes, the record supports that. The Tabbs have been in the business of building and selling homes for over 30 years. They sold hundreds of homes, they testified, and that's what they were doing in this case. Their company, Tabco, as I said, bought the property, and then they constructed this house and then eventually sold it to Mr. and Ms. Hall. And so the record does support finding that they were in fact engaged in a business. The Tabbs did make an argument that this was an isolated sale, but it's not an isolated sale in this case. And it was part and parcel.
Condor,
Yes.
Mr. Condor,
Yes.
let me ask you a question, please. Did the trial court state specifically why the act was not applicable to to your clients?
Yes, Your Honor. The trial court said that they were not consumers.
Okay, and did the trial court elaborate on that? Since obviously they were purchasers of real estate, what does that mean? I'm just curious.
Judge McGinley, he said that he didn't think in this case the Tennessee Consumer Protection Act applied to a real estate transaction, although he allowed that as in some cases they do. And he said that he does not think the Halls were consumers. And then he finished that off by saying they didn't consume anything. And we think that they in fact are consumers in that they purchased this house. And that was the extent.
Okay, so if we try to distill that down, they're not consumers. First of all, the act doesn't apply normally to real estate transactions, but if it did, they're not consumers.
Correct, Your Honor. I think that's
Okay.
a good summary of it.
Okay. Any reason why they're not consumers?
From our point of view, Your Honor, there is no reason they're not consumers. And as I said, Judge McGinley just simply said they weren't consuming anything.
Okay. Judge McGinley did not elaborate then.
That's correct, Your Honor.
Okay. Thank you.
Yes, sir.
Let me ask you, Mr. Condor, if we believe that you're correct, that the act applies, what relief are you requesting?
Your Honor, we would ask that the court remand it to Judge McGinley after finding that the Tennessee Consumer Protection Act does apply, so that then he could make a ruling on the specific remedies that the Halls would be entitled to under the Tennessee Consumer Protection Act. He denied treble damages because he found that the act didn't apply. And so we would like to go back, and the same for attorney's fees. And we think it should be remanded so that in the first instance, the trial court would have an opportunity to rule on that.
Okay.
The Tabbs also argue, Judge McGinley, let me back up. The Halls settled with Mr. Brasher for $45,000, I believe. Judge McGinley determined that Mr. and Ms. Hall had been damaged in this case, the amount of $43,811, I think is the amount. And then he said because the Halls had already received $45,000 from Mr. Brasher, they weren't entitled to recover anymore. And we believe that they are entitled to recover more. And the reasoning is that the lawsuit against the Tabbs was based on the Consumer Protection Act, intentional misrepresentation, and the lawsuit against Mr. Brasher was based on the statute allowing a cause of action for when the inspector does not conduct an inspection. And under Morrison versus Allen, the Supreme Court held that an insurance company in that case that settled settled the case with the plaintiffs, and then the plaintiffs went to trial with the agent. The court held that in that case, the agent was not entitled to the credit or the set off of what the insurance company paid because the causes of action against the two were different, and the agent did not show the extent to which the amount of money awarded was covered by what had already been paid out in the settlement. We believe that's the exact same situation here, that you have different causes of action for different kinds of damages, and that under those circumstances, the Halls would not be, the Tabbs would not be entitled to a set off of that amount of money.
Conda,
No, I'm sorry, go ahead.
how the damage is different in connection with
damages are different in
theories of
that
liability? How are they different?
they're
You understand
different
my
in
question?
that yes, Your Honor.
Okay.
Yes, Your Honor. Can you hear me?
Yeah, I can hear you.
Okay. I think the damages are different in that the Halls had more than just a problem with there being termite damage to their home. They had the problem of these rotted floor joists that the Tabbs had sent a crew out that they supplied the materials to scab over these rotted floor joists. And even Timothy Tabb, one of the defendants, testified that appliances or a person could fall through those floors based on the condition they were in. And we think that is a broader area of damages than the termite inspector, Mr. Brasher, going out and failing to properly inspect the house.
Yeah. What did your contractors say about that, though, in terms of the damages and the injury to your clients? Because as I understand from reading the briefs, that essentially said that you couldn't distinguish the damages from the water versus termite, and the work that was accomplished would have been accomplished whether it was one or the other.
You're correct, Your Honor. Mr. Jones did testify that he could not distinguish between the water damage and the termite damage. And if the court were to find that Judge McGinley was correct in allowing that credit, we still believe that we're entitled to present a case before the judge on treble damages and on the attorney's fees under the Consumer Protection Act. That credit would only take care of approximately $45,000, I think, of the amount of money.
Was your measure of damages, I mean, what actually went into them, the same for the claim against the builders and the same as the termite inspector under the contract, under the statute? Now, were there elements of damages that you might have been able to recover against one or the other that you couldn't recover against the second defendant? I asked that very poorly.
I understand your question, Your Honor.
Okay.
It was not a poor question. The difference is that under the termite, in answer, I think it would be difficult because the contractor couldn't separate the two. It would be difficult to say that the damage, that the measures or the proof is different, except in the fact that the proof for Mr. Brasher, had he gone to trial, would have simply been that he went to the wrong house when he went out to do his inspection. And it's more of a negligence kind of action on his part, as opposed to intentional actions on the part of the Tabbs.
So your compensatory damages, in effect, was the amount that the judge awarded. Is that right? Your compensatory damages. There
were some elements of damages that the Halls asked for that the judge did not award. But yes, you're correct as far as the cost of repairs of the house. That was covered by the damages that Judge McGinley awarded.
But these other damages you suggested at trial, you did not appeal the judge's ruling with respect to those damages, did you?
No, you're correct, Your Honor. You're correct.
Okay, all right.
I see my time's expired. If there are no
Yes,
questions, I'll mute myself.
you have your time for rebuttal. We'll hear from the appellee.
Thank you, Your Honors. My name is Stuart Breakstone, and along with Mr. Vivar, we represent the Tabbs in this matter as the appellees. A couple of things that need to be brought out. You know, even if if Judge McGinley erred in saying that the Tennessee Consumer Protection Act did not apply, and it's consistent that it does not apply to this particular case, his rationale or reasoning may have been a little short-sighted or not as verbose as we needed, but it should not apply to this case. And one of the big reasons that the Tennessee Consumer Protection Act should not apply is because of the open and obvious issue that we have in this case. And this case is similar to other cases that this court and other courts have addressed on the issue. And that is where there was no reason or no basis for the appellant to go underneath the slab, have it inspected. He had all sorts of opportunities to do what, have that inspected and looked at himself. And he chose not to look at it himself. And his own expert, the contractor expert, testified that if he had gone under the house and conducted any sort of inspection or even looked at it, it would have been open and obvious. There was a similar case where a lock was placed on something, and there was no proof that anybody asked that the lock be removed so they could allow inspection. Here, there was no impediment to being able to go underneath the house to inspect it. There was no impediment to finding a home inspector, even though the appellant, depends on which time he testified, whether there was home inspectors available in the area, or what efforts he made to find one. And if you listen to the expert that they brought in, there are home inspectors all over the place available for inspecting this property.
Mr. Breakdown,
Yes, Your
the
Honor.
case you cite involving the lock, that was an as-is transaction, wasn't it? Where there was no disclosure, there was no residential real estate disclosure required.
That is correct, Your Honor, but somebody can't just sit back and rest on that when, because a lot of defects in this case, I say it's late and it's right out there in plain sight if you go look for it, but that doesn't mean, my client had not inhabited the house for years, and he knew that before he purchased this home, because when he went and then looked at the home on several occasions, the home was vacant. There was no furniture, so it was obvious nobody was living there. And still, that does not discount his the requirement on him to help himself. And in this case, because it was there open and obvious, he had the last chance to go and inspect the premises. Also, here's another distinguishing factor why this is not covered by the Tennessee Consumer Protection Act. Even if you go to the expert testimony.
Let me make sure I understand your argument, Mr. Breakstone. Are you saying the transaction is not covered by the act, or are you arguing even though it's covered by the act, there should not be an award under the act? Those are two separate and distinct things.
I'm arguing both. I'm arguing that one, my clients were not in the business of selling real estate. They were in the business of constructing homes. This was not a home that they built in the normal course of their business. This is a home that they built to house workers, to use as a hunting cabin and other things that they later decided to complete the house and sell it. So this was outside the norm of their business. And so they were not in the business. So for that reason, the Tennessee Consumer Protection Act does not even apply. But
let me make sure I understand that argument. Are you saying your clients were not in the business of building homes and selling them?
My clients were in the business of building and selling homes. I'm not saying that they were not. What I'm saying is this particular this particular construction of this house and use of it, and then later selling of it, was not done in their normal course of business. They did not build this house to sell this house. They built this house to use for a hunting cabin, to house workers and other things, and then later decided to sell the house to complete.
So then they completed the house.
That is correct.
After they decided to sell it, they completed the house and then sold it.
That is correct.
So they built it. I mean, you agree the proof is they built it.
They definitely built it.
And they definitely sold it.
At some point in time, they definitely sold it.
Okay. And as I understand your position, is that since they took longer to complete it than normally, or they did other things that were not their usual practice, that somehow or another that takes it out of being a home built and sold.
Well, it takes it out of the purview of a home built for the purchase of selling, which is the business that they're in. They built this home not for the purpose of completing it and selling it. They built it for a hunting cabin for themselves. They built it to house workers.
I understand that, but I mean, am I correct that they chose to sell it and then they completed the building?
That is correct.
All right.
And that actually takes me right into the reason why, even if the Tennessee Consumer Protection Act does apply, that it doesn't apply to this case, or the defense to that would make it not applicable. And that is because the appellant's own expert testified that until a certification of completion is filed, then the house is still under construction, and therefore any work done is not considered repairs, but part of construction. And the expert said that any repairs made before complete would not be considered repairs that would have to be disclosed on the form that my client filled out, because that would have been during the construction phase of it, not subsequent thereto. And so therefore, one, you have the fact that my client did not have a duty to disclose anything on that form that occurred during the construction process. It was only things that occurred after construction that had to be disclosed. And the fact that these defects, the termites and the water damage, were open and obvious, that if your honors reverse the trial court, it's not a matter of just simply reversing to determine what damages are, whether the damages should be trebled. You would also need basically to revisit the entire Tennessee Consumer Protection Act and the defenses that we have pled, because they were not considered by Judge McGinley, because he found the act did not even apply. And also there's another issue with the plaintiff's damages, and that is the plaintiffs did upgrades, or I say plaintiffs, appellants. They had upgrades done on their property. They put in different countertops and other improvements that were not recoverable in this cause. And the proof was that these were done and should not have been allowed. So under that, also the amount of damages that were awarded, if it gets back to that, should be reduced by the amounts that were not caused by my client. Your honors asked questions of the appellant earlier that talks about whether the damages were distinguishable from the damages caused by the termites. Plaintiff's own expert testified unequivocally that whether there was never any water damage, the same work would have been done. Whether there was never any termite damage, the same work would have been done. You could not distinguish one from the other whatsoever. And so in that instance, Judge McGinley was proper to give credit for the amount that the appellants were compensated by the termite person.
Let me ask you, Mr. Breakstone, if in fact this is not a case of joint and several liability, are you entitled to a credit for what was paid by the termite company?
Absolutely. And that is because the damages in here were indistinguishable from one or the other. And there's only one, the appellants would only be entitled to one recovery for the same damage, because going back to the expert who said the same work would have been done but for either A, the termites, or but for B, the water damage, and you remove either one of those, it would be the same measure of damages. Well, you had both, so you only have one measure of damages that the appellants are entitled to recover. They would not be entitled to recover two damages for the same issues. They wouldn't be recovering $90,000 for $45,000, and it wasn't $45,000. But for $45,000 worth of damage to the same area, they would not be entitled to recover $90,000 when the damages are indistinguishable as they are in this case.
So is that because there's a prohibition on double recovery? Is that what you rely on?
Your Honor, I just rely upon, I guess, comparative fault, the intent not to allow double recovery for the same measure of damages, and the fact that in this case, it was brought out and part of the proof that they've recovered $45,000. It wouldn't be a collateral source rule because it was for the same damages that would have been done whether or not my clients there was a water leak or just a termite leak. And I don't know if I answered your question or just beat around your question, but I answered as best I could, Your Honor. So for those reasons, Your Honor, we would just ask that this court affirm the trial court and find that even if Judge McGinley did not state specifically the only basis for him saying that this transaction did not apply was because the appellant was not a consumer. His reason was right. His rationale may have been a little bit off, but the reasoning was right. And we would ask that you affirm that and in all respects and allow the appellee to go henceforth.
Thank you, counsel. We'll hear from the appellant in rebuttal.
Thank you, Your Honor. Nobody in this case wishes they'd had an inspector more than the Halls do, but there's no requirement that they had to go out and hire an inspector when they relied on the disclosure forms provided by the Tabbs, who did in fact build this house. Now, it took them a lot longer than they do on their normal houses, but they still built this house. And while it was in this long period of construction, excuse me, they did allow folks to stay in it. They had a crew that would stay in there sometimes. And they would also allowed some hunters to stay there. But the fact is that they did not live in this house. They built this house and sold it like they did in the ordinary course of their business. And the Consumer Protection Act should apply on that basis as well. And the Judge McGinley rejected this argument that the house wasn't complete until there was a certificate of completion issued. He said that was just an attempt to get around selling this house to these folks that when it was in this terrible condition. And he said that wasn't, he wasn't going to consider that to be part of construction, but those were repairs because the floor joists were in. And at some point they went out there and replaced those, or tried to repair those joists. They sent their crew with their materials out there to repair those joists in that scabbing method. And as far as the upgrades, there was testimony that upgrades were performed, but the defendants did not put on any proof to show what the amount of money was on those upgrades. And based on that, Your Honors, we would request that the court reverse Judge McGinley on the Tennessee Consumer Protection Act and send the case back for him to analyze it under the Consumer Protection Act.
Of course, thanks to counsel for both sides for your briefs and for your oral arguments. I think we understand the issues and the positions. Mr. Hibner, if you'd recess court until 3 o'clock this afternoon.
Thank you, Your Honor.
This honorable court is now in recess until 3 p.m.
Thank you, gentlemen.
Thank you.
Thank you.
Sorry about that. I was watching the YouTube video thinking that was live. I was like, all right, cool. The time's up. And they just counted. And I was about to put you guys in the breakout room and realized, oh, I'm watching on YouTube. That's not good. It's a good 10 seconds.
When Judge Armstrong comes back on, will you change his name to Judge Armstrong?
Yes. Yes, I can do that.
I missed that.